Sergeant Vusimuzi Mogane has maintained that accused number 2 in the Senzo Meyiwa murder trial was not tortured into making a confession statement. Sergeant Mogane drove Bongani Ntanzi to where he made his first confession statement, which Ntanzi alleges he was tortured into making. Today's court proceedings were overshadowed by a scuffle, not really, as the judge has said that he will not be making a ruling on it or will not be asking anyone to swear. He merely just wanted to find out what happened. We get into today's developments, including the testimony with legal analyst Mpumelelo Zikalala. Thank you very much, sir, for your time this afternoon. Perhaps let's take a look at the testimony as we have heard it over the past couple of days from the AVL expert, including Sergeant Mogane and Sergeant Mogale. How helpful has it been, and to whom?
Good afternoon to you, and also good afternoon to your viewers. Well, it's helpful to the accused in this case because they've been maintaining all this while that while they were traveling, there were certain stops that were taking place, and no one can be able to account what was happening in those particular stops. So it suits the story, or it's much more probable with their version in terms of saying, while we were stopped, we were being beaten, there was undue influence which was put onto us, the number of treatments that were then undertaken to us, hence why you have a confession which the state is calling a confession, while on our side it's not a confession which was given voluntarily, hence why we have the trial within the trial type of situation right now. And in fact, this is aiding the accused because it is fitting perfectly to their story. Another reason would be, why would a reasonable police officer in their shoes choose to engage or to travel in a car which keeps them breaking down? Why would they stop for such an amount of minutes where there's no accountability as to what exactly they were doing? Why not turn back and go get a car which is much more viable or much more suited for the type of activity that they were engaging in? You are traveling in a way with the accused persons that you would regard as being dangerous. Why do you want to put yourself in that vulnerable state? So what has happened now is that it has suited, or it's in favor of the accused, in saying or proving to the court that the probabilities of what they are saying is true, they are quite high.
When we take a look at some of the details that we heard today, the legal counsel that works with Advocate Mshololo mentioned a particular date and how for 17 hours Sergeant Mogane was with the accused. From the work that you do, is it unusual for arresting officers, investigating officers to be with a suspect for that long?
It would be unusual. We are talking about more or less 2 full days in terms of the normal working hours. The question that is, what are you doing within a particular time? What about the rights of the accused? They know exactly as to what to say and what not to say. Has that been carefully explained to them? As you are traveling in these particular routes in which you are taking, what exactly are you doing with them? So that's the most important and crucial question that comes about, because when it comes to criminal law and the legislation and the manner in which our courts work, they say, yes, you can collect as much evidence as you want, but the evidence or the manner in which you need to collect that evidence must still suffice and be in line with the conditional provisions which are applicable to us. So you may collect evidence, however, it cannot be used in court because it was obtained illegally. So within those 17 hours, such a long time, what exactly are you doing? Are you not perhaps engaging in tactics which are not desirable? Are you not engaging in tactics which cannot be utilized, or that will cause whatever evidence you've collected, no matter how good it is, to be excluded by the court because it was collected in an improper manner?
Let's revisit a moment today when there was a scuffle between some of the accused and the warden. Let's listen to the version of the warden.
The fourth suspect was the one who started the whole thing. Then on the 15th I came and I was like, no guys, we cannot allow each other to sit like that. This is a court. Yes, it is an adjournment, but now you can stand, you can sit like in a proper way, but you cannot sit on top of that like I just showed. So later on, my colleagues, I was talking with my colleagues that, listen, tell me if I'm doing the wrong thing. Are they sitting in a proper way? Then they were like, no, this is wrong. Okay, I let it loose. And I was like, no, maybe when we go down, we need to address them. Now, before we went down, one of them, I cannot recall which one of them, he was sitting this side, facing that direction. Can I show you? He was sitting like this. shouted again. I even shouted again. Listen, you cannot sit. This is not a proper way of sitting. Luckily enough, the orderly, the lady, saw it. So now we went down. It was a adjournment again. I called it in the set. I was like, I tried to stop this thing, and you were howling at me. I was a bit not sure to call you into order in front of them. So they were like, no, this is not your job. You cannot tell us. Your only job is to escort us to here. Then I was like, that's whereby you are not getting it right. You are my duty as long as you are in front of me. That is why I'm forever standing there. I'm watching you. I'm observing. I'm monitoring every movement. So I tried to speak to the orderly, to perhaps speak to the prosecutor or you. Then he was like, no, she's going to take it out.
Mpumelelo Zikalala, the judge then asked that Section 159 be read out in terms of the decorum or how people must conduct themselves in the court. He didn't ask anyone to swear to give their version of events. But that moment, it tells you what, if anything at all?
Well, it does tell of the high friction and the high tempers which are there in court, and it's understandably so. We are dealing with a matter of life and death. It's a high-profile case, and definitely it being televised adds to the high pressure that is there. But I think what is important in this case is that the court or the judge reminded individuals of the type of decorum that must be observed in court. But most importantly, whenever there's a complaint, regardless whether that comes from the official of Department of Correctional Services, you must be able to channel it in a proper manner. I think the involvement of the defense counsels would have assisted in this case. The involvement of the prosecution would have assisted in this case. The person who presides over the particular court, which is the court orderly, would have easily stood up and said, this is the way things are to be done in this particular court. If you do not listen to what we are telling you, then we'll report it to the judge, instead of the scuffle that has taken place, which does not suit nicely or does not look very good in terms of the way things are supposed to be. And remember, they still have to travel back today, back to the prison. Now, one would wonder, well, how is that particular route going to take? Is it going to be safe travels, or is this level of friction still going to continue? I think the court was correct in terms of saying, let me remind you the type of decorum that must be here, even when it comes to the way in which you sit. This is how you are going to behave.
Mr. Zikalala, sir, thank you very much for your contribution this afternoon. Mpumelelo Zikalala is a legal analyst.